Case number 19 CR 67. And my was James Michael Evans, present for the state as Assistant Prosecutor Kane. Present on behalf of the defendant is Dennis Kirk. And are you James Michael Evans?
Yes, sir.
Right. And is Mr. Carr appearing on behalf of the probation department as a drug court officer. This is a hearing on violations found on June 11th by Officer Carr, alleging that Mr. Evans violated Rule 7 of the Control Drug Court conditions. And before 6/11/21, he used fentanyl, and that's claiming in effect. The court appointed Mr. Kirk and subject matter for an evidentiary hearing. Mr. Kirk, if you have opportunity to review the allegations of the client.
I have, Your Honor, and I've advised him of his right to the hearing. He does wish to waive that hearing and commit to the violation as filed on June 11th.
All right, Mr. Evans, you do have a right to have a hearing in which the state is required to present evidence to prove that you have committed this violation. You have a right to have your attorney cross-examine those witnesses. You have a right to present evidence on your own behalf and to testify on your behalf, although you're not required to do so. And if you don't, vote against you. In the event that you admit to the violations, one of three things can happen. I can continue on being controlled in the drug court as on the same conditions previously ordered. I can continue on additional conditions that I think are appropriate, including extending it to 5 years. Your community control it is. Or the third, and the most serious, is I can revoke your community control and sentence you to prison. And and plead guilty to felony 4 of the league of drugs, so that would be a possible sentence of 18 months in prison. Okay. You understand your rights in the hearing?
Yes, sir.
You understand the consequences if you admit to the violation? What could happen?
Yes, sir.
Has anyone promised you anything or threatened you in any way to get you to admit to these violations?
Right.
All right. Do you have any questions then about the allegation?
Right.
You admit or deny?
But
All right. Anything from the state or the probation department?
Thank you, Your Honor. This is the defendant's third probation violation since being placed on community control back in July of 19. He's been given chance after chance, continues to squander those chances. So at this point, it is the position of the state as well as the probation department that he's not amenable to community control, and would ask this community control be revoked and be sentenced to term of incarceration.
Right, Mr. Burke.
Thank you, Your Honor. This is a situation that normally I would think I could see the court just straight sending to prison. Obviously, like the state outlined, it is the third violation. However, there are some mitigating factors in this particular instance. My client was at STAR and began to have medical problems. States to me he advised them of that, and they kind of put it on the back burner for a while until it reached the point where an emergency of a medical event happened and he was taken to Portsmouth Hospital. He was then transported to OSU, or Riverside Hospital in Columbus, and upon there, he was there for several days. Ultimately ended up in the Laurel's nursing home for rehab care. He has had a spinal infection, a cyst on the left side of the spine. I believe the cyst is still there and needs to be addressed yet, as well as he's currently having kidney stones and is still under the care of a doctor. He did report to the probation department, so he did not abscond this particular time. He was dirty, advised me he's in quite a bit of pain, didn't handle it correctly, and obviously relapsed. In this particular case, if we could get him back to STAR and stabilize his medical issues, I'm confident and hopeful that he would be able to succeed. I know that we've tried a lot here in this case, and I hate to see it end in prison when he was one of the first drug court participants. And speaking to him, I think if this medical stuff wouldn't have happened and he remained at STAR, we might have been looking at a different story right now. So would ask the court to consider continuing the community control with drug court and STAR or any other appropriate treatment facility. My understanding is STAR could have a bed approximately July 7th for him. If he could be continued in custody until then and released to STAR. Again, I understand normally this would just be prison with this third violation, but I think with these medical problems, certainly doesn't excuse the behavior, but it explains a lot of it, as opposed to some of the violations we see in this court. Thank you.
Mr. Evans, anything you'd like to say?
Yes, sir.
Well, yeah, Mr. Evans was on our first three persons admitted into the drug court, and probably that has influenced my feeling in the past and handling his violations. Hoping that he'll be able to turn around. But admittedly, him having to leave Star is not your fault. There's no question about it. He had medical issues and bona fide serious medical issues. Obviously, we're going to rehab. So the problem is how you handle that when you got out. And what we've seen from you, Mr. Evans, is a repeated relapse, no matter how much support you're given. And I'm thinking maybe in this case we gave you too many chances, and you just thought that there was an unending supply of that. I know when you went through the counseling center program, well, first you started out in Massey House. You got out that day with Walmart and Mr. Zorns and ran from there when a buddy went out got high, and then we put you at the counseling center. And then you worked through that, got into transitional, you were independent living, working, and relapsed. And then we went back there. And then you ended up going over to the counseling center, another relapse. And despite the fact that probation has done just about everything possible they know to do. And probation is down, and they're just done because they've done everything they can. And I've cautioned you before about the fact that you always felt that you had the answers and that you were always more confident than that you really were. And at this point, at some point, I have to put the let's use an old phrase, lay the law down. Say, you know what, we're done, and that's where we're at. We're done. I just don't think you're serious about it. You were in a nursing home, too ill to go back to the Star, but not enough to get out on the street and buy. If it was just simply a matter of pain fentanyl, then that's the pain reliever, that's the opiate. But then you're using meth and amphetamines, and you have had chance after chance after chance, and at this point, I just can't justify giving you another chance. So that's important. Okay. So the court finds that notwithstanding the fueling efforts of the probation department, that the defendant's not been legally community control, and therefore we go to court that you be terminated from the drug court docket, that is community control be revoked, and that you be sentenced to Department of Corrections at Reception Center, Ohio, for a period of 15 months. How many days you had to start, Mr. Park? You know how many days you had to start?
It's like 30 days or whatever.
Okay, well, you got 43 days of jail time credit. Looks like you went on May the 10th to Star. No, wait a minute, I'm looking backwards. June the 11th, you were back. You went to Star.
I was at the hospital April 12th.
Yeah.
I'll say it's sometime in March.
April the 7th is when he was released transport to Star.
No, they got me. I was in court, and they sent me the next morning.
Oh, did they?
Yeah.
All right. Oh, yeah, here we go. Yeah, I think they ended up in the bed March 19th. Yeah, okay, March 19th. So from March, and then when was it you went to the hospital?
April 12th or something like that.
All right, well, we'll say the 14th, you can better do it down. So that's 26 days to Star, and according to the sheriff, 43 days of credit from the jail. various times. So, we have 43 and 26 would be 69 days. And upon completion of this prison term, it is possible that the adult parole authority will put you on post-release control supervision for a period of up to 3 years. They don't have to, but it's up to them if they want to do that before they have involvement. And if they do, then you will be supervised in the terms they set, and that could be for up to 3 years. And if during that period of time they determine that you have violated, they can return you to prison, they can serve an additional period of up to half of the 15 months term for one or more violations. But violation is a felony, then in addition, whoever sentenced the judge in a new case, including plenty of judge also sentenced in this case to an additional period of 1 year or whatever time left on the 3 years of post-release control term period that occurs that must be served consecutively to sentence in. We also will pay the court costs, which have to grant execution order if we don't do that. Court collect that through various means, including letting on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, once you complete your prison term, the court may have you do service in this county, give you credit for each hour you work, and an hour already set by the court each hour you work to reduce your judgment by that amount until paid. All right, is there anything further from council?
I don't hear
All right, your manifest and questions. Good luck.
Pardon?
All right, Ashley Myers.
That's, okay.
I thought that got separate.
I'm sorry, Heather Tanker, please. Heather Tanker. Ashley myself.
Pardon? That's,
Your Heather? Absolutely. Oh, I'm sorry, we're waiting on Ashley Myers.
tomorrow.
Okay, go ahead and contact her.
Okay.
Okay, we have two cases before the court, both styled State of Ohio versus Heather and Tankersley. Case number 18 CR 124, 18 CR 150. Your Heather and Tankersley.
Yes, sir.
All right. Thank you. You can get them sheet numbers.
Should be.
Okay, case number 18 CR 124. Oh, here it is. Sorry. The defendant was convicted of failure to comply with order signal police officer and grand theft of a motor vehicle, number 3, 4-3 felony. And she was sentenced to prison, I believe, November, December. Here we go. November 19th, 2018. And the term in that case was 9 months on each count, for a total of 18 months. Then 154, she was convicted of aggravated possession of methamphetamine, a 53 felony, and then was also sentenced to prison on November 19th. Last charge for a period of 9 months consecutive, to the 1.4 case for total 27 days. Court granted this, actually judicial release on, June the 1st of 2020, effective June the 9th. Her to, go to treatment and a star to successfully complete the star program in both cases. Now, on June 23rd, court received a notification that actually alleged to have violated the conditions, and that's this morning. And it alleges Ms. Ackersley that she had violated Rule 15, Rule 2, and that she had failed to report to probation since March 4th, 2021. Failed to pay the court costs that are making payments on that, which is Rule 15. Rule 17, you failed to make any restitution payments to the victim witness. And Rule 19 is you failed to pretend or provide any proof of completion of aftercare after being released from STAR. That was signed by Officer Kelly on today's date, and it looks like you signed it this morning, and you did get a copy of this out of jail. Alright. And that, you did sign this, the allegation on looking at, right?
Yes, sir.
Okay. Alright, now, there's time to have a hearing in this matter, Ms. Tankersley, in which the state is required to present evidence that proves to the court's satisfaction that you committed these violations. You're entitled to have a reasonable period of time to prepare for that hearing. Usually that's about 10 to 14 days. You have a right to subpoena witnesses to come to court to testify for you, just like the state. You have a right to have an attorney to assist you in defending against these allegations and to cross-examine the witnesses and to give you general advice regarding their crimes. And if you cannot afford to hire an attorney, the court will appoint one for you. And I see you did fill out an attorney or a financial disclosure form, and are you requesting the court appoint counsel for you? I'm sorry?
I don't look at it well. I know that,
You can take your mask down, because I'm having trouble understanding.
okay, thank you. Can I speak for a moment on my own behalf? So I don't know if I did one of those. I don't even know. I relapsed. That's
My question is,
together.
do you wish to have an attorney?
No, I just want to do this.
Okay, well, you filled out this form.
Yeah, they had me do it, that's fine, I guess I did.
Alright. But has anyone promised you anything or threatened you in any way to get you to give up your right to have an attorney?
No.
You understand that if you don't have an attorney, you'll have to make your own decisions regarding this matter
Yes.
and represent yourself?
Yes.
And you understand that if you're found to have violated these conditions, then you could be returned to prison to serve the rest of your sentence.
Yes.
And so you're certain that you don't want to have an attorney to represent you? It's not going to bother me if you do. It's up to you. You have that right. That's not a problem if you want an attorney.
No.
Pardon?
No, I don't get it.
You don't need, okay. Well, if you don't want to have an attorney, then you get a form signed and put in a file that confirms that you waive that right. So I'm filling in the blanks on this form that I keep here on the bench. The title waiver of counsel, I'll put your name on it, and the two case numbers, 18 CR 124 and 154. And it states that I, Heather M. Tankersley, the defendant herein, being now in open court, fully understanding the laws of the state, I have a right to legal representation and I do hereby permanently waive my right to be represented by counsel. What waive means to give up, permanently means that there's no question about it, you're definitely willing to do this. So if that's your decision, then I need you to sign this form on the line under which you put in a defendant. Now, you can change your mind at any time up to the point that it gets to the point where they're going to find you violated and I'm going to pronounce disposition. But at that time, it's too late. So if you want to change your mind even now, that's fine. It's up to you. It won't bother me a bit. It won't be, any ill will or anything used against you because of that. Understand? Okay. And so do you want an attorney or do you want to waive and give up that right?
Waive the attorney.
All right. Then I'll have to bail to make that over to you. And take a look at that. And if you want to give up your right to have an attorney, and again, it'll be paid for by the court, by the state, then sign it. If you want an attorney that don't sign it, we'll appoint an attorney for you. All right, and that's your signature on this waiver of counsel form that I just read to you?
Sorry.
All right. Okay, the next step, Ms. Tankersley, then would be to either admit or deny the allegations in the notification. If you deny them, then we'll set the matter for hearing in about 10 to 14 days. Give you time to prepare. Subpoena witnesses, you might want a subpoena. And then we'd have a hearing, and there'll be witnesses, and the state would have to present the witnesses. You can cross-examine them and present evidence on your own behalf. If you admit to the violations, then that means you're admitting that they're true, that you committed those violations. And then at that point, the court will decide whether to continue on committing control, judicial release, continue you with additional conditions that are appropriate in the court's judgment. Or the third, the most serious, is revoke your community control and return you to prison to serve the rest of your 27-month sentence. You understand that?
Yes, sir.
Have any questions? No. Then you admit or deny the allegations of violation, conditions, probations that I read to you that were filed this morning.
Admit.
Okay. Mr. Paulson's here. Probation Department have any statement regarding this?
Officer Sandy Kelly filed a violation. I don't think she has any more to add than I would.
Okay.
Ms. Tankersley went from prison to Star to Montgomery County. We really haven't dealt with her, so I really can't really say. I mean, the violations kind of speak for themselves. But personally, I don't have any dealing with it.
Ms. Tankersley, you have anything you'd like to say?
Yes, I do, Your Honor. I relapsed back in the end of March. Up until then, I reported faithfully. I was involved in my recovery. I ended up homeless in the city of Dayton with no job. Since being back down here, I didn't do things in order. I should have contacted Mr. Walzer. I didn't do none of that right. I do have a job. I work at Taco Bell. I was just hired. I've been there 2 days. I haven't been able to pay on anything because I didn't have a job. I didn't have any stability or nothing. I have a home and roof over my head here. And I'm asking the court to give me a chance to do the right thing. I mean, I have gainful employment. I have the ability to pay my fines and to pay all my restitution, to be able to see him. I live right in town. Everything's in walking distance. But I know that I need support and I know I need help. As in FRS, I even checked in with the Nova House and things like that, and I couldn't get in anywhere. And I came down here, and my aunt gave me a roof over my head. So and some stability and a push in the right direction. And I finally just got hired on at Taco Bell. It's my first job ever in my life. I'm 42 years old. I've never had a job until. I'm just asking the board to take into consideration that, or maybe drug court would be something for me. You had mentioned that back at the beginning of my judicial, and I don't know.
What did you do in Montgomery County?
My mom and my kids, and that was the wrong idea.
I know because when they went to visit your house, your mother said you had left and were living back down here.
Yeah,
She didn't know where you were.
my mom threw me out. My mom and me do not get along, no matter what I do.
Because you were using probably.
No, I haven't started using that. I haven't started using that. We don't get along, we
When
never
did she
got
throw you
along.
out?
So it's,
When did she throw you out?
in March,
Well, why?
because I didn't have a job yet, I didn't have any money yet.
When'd you get out of Star?
I got out of Star November 10th. I didn't have any money either. Me and my mother do not get along ever since my father passed away.
Then why'd you go there when you got out of Star?
Because I tried to be a mother for my kids. And it fails me every time.
Well, back here at your history. You've got this long history. But drug court's only if you have it, if you're a resident of this county, you are in a Star. And you're the one who wants to go back to our county, which is a big mistake, obviously. I'm just looking here, you've had probation numerous times. And despite your history, the court took a chance when you granted you just release. You didn't follow through with anything about drug court or anything. You went on Montgomery County and after that, you've been in prison two different times. At least, you had a illegal assembly and got probation in Wilmington. Then apparently illegal assembly in this county went to prison. 2013, illegal manufactured drugs. 2014. And your history is, say you need help and then you had opportunities for help and you were given this chance and you blew it off. So it's judgment in court that your judicial release be revoked and you return to prison to serve the balance of your sentence. You can get jail time credit for the time you were in Star. Now, how many days you were in Star?
154.
154. That most people enter about 90 to 100 a day. You get 154 days additional credit plus, I think we were arrested yesterday. 1 day in the jail, 155 days. And on completion of the prison term, we have the authority to decide whether or not to put you under post-release control supervision. If they do, you supervise the terms they set. If you violate those, they'll be able to return you to prison for an additional period of up to 9 months for one violation, the maximum of half of your prison term for all violations. But if you commit a new felony, then in addition, whatever sentence the judge in the case impose, that judge is also authorized to sentence in this case to an additional period of 1 year, or whatever time that long period of post-release control, whichever period that occurs, that must be served consecutively, the sentence in the case. You're remaining in custody. So, you're remaining in custody. Alright. Go ahead, Mr. Ray,
They're in the jury room, Judge, discussing.
And, no, don't tell me that. Don't tell me. She went with it. Case number 15, CR 0124, Dale High versus Gregory Russell. For the state's assistant prosecutor, Pat King, have defense attorney Daniel Witt, and probation officer Paul Stewart is present on behalf of the probation department. You're Gregory Russell.
Yes, sir.
And Mr. Russell was sent to prison back in 2015 with 3 different cases, one of which I believe had a 5-year bag for him. He was convicted in this particular case of illegal assembly and was sentenced to 12 months in prison. Second to that sentence, there was another conviction of 79, of which he was sentenced to a period of incarceration. The court granted Mr. And actually, there's 3 cases, or 2 cases here. I believe that the original sentence in the 106 case has been served, and it was granted judicial release of 124 and 79, if I'm not mistaken. The entry was granted as filed on January 22nd of 2021. I'm sorry, that's one over the investigation. The occurred on February 17th. February 17th, and he was granted judicial release on February 18th. He released to the sheriff when we started with veterans and And looks like that would have been, March the 3rd. The court received a notification that Mr. Russell had violated the conditions of his judicial release and that he had been terminated from the STAR program for violation of the programming rules. In a matter of, court notified him on June 15th, appointed counsel to represent him and set the matter for hearing. And Ms. Wood, you have an opportunity to look at the allegations just on the one count, 19A.
Yes, sir.
Correct. All right, and we going to have a hearing, or is Mr. Russell going to admit to the allegation?
He will admit to the violation.
All right, Mr. Russell, you have a right to have a hearing on this, on the declaration of whether or not you can complete the STAR program as ordered. You have a right to have the witnesses that the state presents cross-examined by your attorney. You have a right to present evidence in your own behalf, both as to the violation and as to the disposition of your found with violation. You have a right to testify on your own behalf, although you're not required to, and you can't be required to. And if you don't testify, that won't be used against you. Now, if you admit to the violation, one of three things can happen. You continue under community control as before, and you continue you on additional conditions that think are appropriate. And the third, and most serious, is that you revoke your judicial release, return you to prison to serve the balance of the sentences in 15 CR 79 and 106. I'm sorry, 15 CR 124 and 15 CR 79. All right. Do you understand the allegation, Mr. Russell?
Yes, sir.
You understand your rights to the hearing?
Yes, sir.
And has anyone directed you in any way to get you to admit to these violations?
No, sir.
All right. You have any questions then about the allegation?
No, sir.
You understand it?
Yes, sir.
All right. Then do you admit the allegation that you failed to complete the STAR program as ordered February 18, 2021?
Yes, sir.
All right. Anything from the state or probation department?
Thank you, Your Honor. The defendant was granted judicial release back in February for a complete STAR. He got the STAR on March 3rd. He was unsuccessfully discharged on June 14th after repeated rule violations, continued to show aggressive behavior, causing a safety and security threat to the facility. I think it's clear that he's not amenable to control treatment, and therefore asking his judicial release to be revoked and he be returned to prison.
Right, Ms. Wood?
Yes, Your Honor. We are in agreement that he did have rule violations. However, while they were still infractions, they were minor. Many of them were minor infractions, such as leaving his ID hanging on the door, leaving his towel hanging out, and just kind of minor things like that. Mr. Russell was doing a very good job in STAR. He had 14 days left. He completed all of his classes. He became certified in plumbing, earned his GED, so I think that he is amenable to community control and ask the court to consider either a CBCF or returning him back to STAR.
All right, Mr. Russell, do you have anything you'd like to say?
Yes, sir. I took STAR seriously. I completed all my classes. It helped me in a lot of different ways, and I'd like to go back if I could, or another program.
All right, anything else?
No, sir.
Well, the STAR kicked you out, so they're not going to take you back, at least for a long time, until there is a change in your attitude. But I'm looking at your violations for 14. 5 of them were considered major rule violations. And what led to your discharge was that you had become very disrespectful with a staff member back in June. So you were placed back in classes to further address your issues. And then 14th of June, he made threatening comments to another resident, threatening to assault him and threatening to go to the bathroom fight. And due to your continually aggressive behavior, they felt you something more illegal. Now, you should remember what I told you. I said, after successfully completed. It doesn't mean 80%, doesn't mean 90%, doesn't even mean 99%, it means 100%. And then we've been there for 103 days. They could have kept it for up to 180. And I know that you said you only had, you told your attorney you had like 20 days left. After what had happened, I'm sure that wasn't correct because they put you back into repeat classes. Those discharge days are just goals because I've seen people don't get to the point where they're ready for discharge, and so sometimes we get up to 180 days. But again, I let you out of prison, committed a number of different felonies, very serious felonies, and I gave you a chance once you completed your mandatory prison term, and you couldn't get through STAR. And so that was a requirement. So it's the order and judgment of the court that you have your judicial leases hereby revoked and terminated complete control, and you'll be ordered to be returned to prison to serve the balance of your sentence. You'll be given additional credit on your sentence from the time you release from prison to the jail and then STAR and then back to jail. And 103 days in STAR and 12 days in jail. So that'll be 115 additional days of jail time credit. Now, upon completion of your sentence, the adult parole authority, actually, I think because you had mandatory, in the other case, when you're mandatory, you should be on probation of those least control for 3 years. It's optional in these cases. And you are found to have violated those conditions during that 3-year period, the parole authority will be able to return you to prison and make you serve like an additional 9 months of one violation up to the maximum of half of the total prison term that you served, which I believe was 5 years plus 12, and Reverend Devlin was maybe. But anyway, I think 36, so I think you actually had about 9 years. So in any event, the 1/2 of whatever the term was for all violations, but if you committed a felony, in addition, whatever sentence the judge in your case to impose upon you, that judge also authorized the sentence in this case for an additional period of 1 year. Whatever time left on that 3 years post release control, whichever is greater, that occurs, that will be served the second release sentence again. Anything further, counsel? After remand in custody.
For tomorrow. They bring it tomorrow. Yeah. We're done, Judge.